And it looks like you are unmuted, Mr. Lin. Do you want to try communicating?
I don't see a mute button for him.
Yeah, now he doesn't have even a mute button.
All right, I think we're going to get started. So it is 4:12, and I want to welcome everybody to the first Redistricting Advisory Committee meeting. My name is Nicole Fife, and I work with the Pima County Administrator's Office. And we're going to start with roll call. And if those of you can unmute yourself and say here when I call you your name, that would be fantastic. And we'll try first with Steve Lin. Steve, are you there? And we can come back to Steve. Dr. Lee?
Here.
Thanks. Mr. Hecker?
Here.
Mr. Antonori?
Here.
And Dr. Romero?
Here.
Thank you. And now we're going to do the Pledge of Allegiance. If you would please join me for that. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
With liberty and justice for all.
Thank you very much. I'm going to go through this agenda until we get to the election of committee chair and vice chair, and then whoever takes that role can take over the meeting. So we are at agenda item number 3, purpose of the committee and introduction of committee members and county staff. And the purpose of this committee, the Board of Supervisors has asked your committee to hold at least 5 public meetings to develop a map or maps to recommend to the Board of Supervisors that they would then adopt by May or the end of May. And so they're asking that you complete your work by April 30th. And we'll go over that in a little bit more detail further down. At this point, I'm going to ask my coworker, Diana Drazer from the County Administrator's Office, to read a short statement to any Spanish speakers that we may have that are watching so that they can understand how they may be able to participate or provide comments to the committee in the future. Diana?
Okay. Bienvenidos a la Junta del Comité de Reestructuración de Distritos del Condado de Pima. Se podrán proporcionar comentarios durante la audiencia pública hacia el final de la Junta. Comentarios por escrito también se pueden enviar en línea por medio de la página web de este comité. Un traductor estará disponible para traducir comentarios proporcionados en español. Para más información, favor de hablar al número 520-724-8801. Gracias.
Thank you, Diana. So committee members, I'd like to take this time to be able to allow you to introduce yourselves to each other and to anyone that may be watching today. Some of you I know have had experience with redistricting before, either at the local level or at the state level. So if you wouldn't mind explaining what your experience is, if you have had that, I think that would be helpful to your fellow committee members as well as those watching. And so we'll go in order of the districts, and we'll see if Steve Lin, are you there? And I think they're going to try and help Steve still, so. And I'm going to go on to Dr. Lee. You're representing District 2?
Yes, hi. Just want to say I'm very honored to be part of this committee and working with my fellow committee members. Look forward to a successful redistricting process.
Thank you. And Mr. Hecker, who's representing District 3?
Good afternoon. My name is Larry Hecker. I was appointed by Sharon Bronson. I have no experience on redistricting committees other than what I read in local and national news. So I'm looking forward to the exercise.
Thank you. Mr. Antonori, representing District 4?
Hi, Frank Antonori. I was appointed by Steve Christie. My experience with redistricting has been on the receiving end, as I was a sitting state legislature when the state went through redistricting in 2011. So I'm very familiar with the process, although I wasn't directly involved. I was involved tangentially in that process. But I look forward to working with the other committee members and advising our supervisors of drawing the district lines for the supervisory districts in the county community college district. So I look forward to it. Thank you.
Thank you. And Dr. Romero.
So, again, I want to echo the sentiment. I'm proud to be a part of this committee. I was appointed by the Honorable Adriana Halva, and I served on this committee 10 years ago. I was appointed then by the Honorable Richard Elias.
Thank you. And I'm going to go back one more time and see if Mr. Lynn is able to communicate. And I don't see that right now. I can tell you that Mr. Lynn...
Can you hear me now?
Oh, yes, I can. Thank you.
Oh, good. I'm sorry, I had technical difficulties. I'm sorry, pardon me very much for being late. My name is Steve Lynn. I was appointed by the Honorable Rex Scott, District 1. And I think many of you may know me that from 2001 to 2011, I chaired the State Independent Redistricting Commission. So relatively familiar with the redistricting process over that period of time. Happy to serve Pima County.
Thank you, Mr. Lynn. And I appreciate all of you. And I'm going to introduce county staff who will be available to help the committee through this process. And you met myself and Diana Durazo, and we will be the staff that are communicating with you on a regular basis in between meetings also. And I would also like to introduce Mary Martinson, who is our Elections Department interim director right now. And I believe Mary is in a conference room with a couple other of her election staff and may be able to give you a wave if you can see her on the screen. David Wisely also may be filling in from her on occasion, also with the Elections Department, and they'll be available at each meeting to answer any questions you may have. Also, Eric Glenn, who you'll be hearing from a little bit later. Eric is our GIS analyst, and so he is going to be an integral part to this, both during the meetings and then in between the meetings in developing maps and providing you with various data. And you'll hear a little bit from Eric today. And then just by having these meetings, and you can already see that at the beginning it takes a lot of sort of back and forth. So Nico and also Sean will probably be providing assistance to you in getting you into these meetings each time. And hopefully it goes smoother the more meetings that we have. Also wanted to point out today we have with us Bobby Yu with the County Attorney's Office, who will be doing the open meeting law and conflict of interest training. And in the future, Pam Franklin from the Recorder's Office may join us too if there's questions that have to do with voter registration and the data that we'll be using as part of redistricting from the Recorder's Office. So at this time, we can move forward with agenda item 4, which is election of committee chair and vice chair.
You know, it seems to me that Mr. Lynn has the most experience with this type of a process, and this may put our long friendship at risk, but I would nominate him. I would nominate Steve Lynn.
I actually would second that. Yeah.
Is there a second for that?
Second.
Oh, Dr. Lee seconded that
I think
motion.
somebody else did too, but I'm not sure.
That's fine. That's fine.
So let me ask that, because we're doing this remotely, that when we have votes, we're going to do roll call votes. And so for Mr. Lynn as chair of the committee, I'm just going to go down the list. Mr. Lynn?
I'll abstain for obvious reasons.
Dr. Lee?
Yes, aye.
Mr. Hecker?
Aye.
Mr. Antonori?
Aye.
And Dr. Romero?
Aye.
Thank you very much. And welcome, Mr. Lynn, as chairman of the committee. Do you want to take us from here?
Yes, I'll be happy to do that. Let me first start with my first inaugural address. It's only about 45 minutes long, and I know you all want me to hear it. But to be serious, the next item on the agenda is a vote for vice chair. Is there a nomination for someone to serve as vice chair of the committee?
I would like to nominate Dr. Romero, because he served on the 2010 redistricting. So both of you have good experience in this.
Thank you, Dr. Lee. Is there a second to the nomination for Dr. Romero?
I would second that, Mr. Lee.
Moved and seconded. Is there any discussion on the motion? Hearing none, we will do a roll call again. Would you please read the roll?
Sure. Mr. Lynn?
Aye.
Dr. Lee?
Aye.
Mr. Hecker?
Aye.
Mr. Antonori?
I'm going to vote nay.
And Dr. Romero?
I'll abstain.
Thank you. Well, congratulations, Dr. Romero.
By a vote of 3, 1, and 1, Dr. Romero, you are the co-chair.
Congrats.
Congratulations, and I'll look forward to working with you on agendas and other issues as we move forward. Be my pleasure.
Likewise.
Item 5, Committee Open Meeting Law and Conflict of Interest Training. For those of you who have served on the committee before, and certainly those of us who served on the State Committee, this will be our 7th or 8th go at open meeting and conflict of interest training, but let's begin.
And that is Bobby Yu.
Good afternoon. I don't have the ability to share the presentation on my end.
Sean, can we start the open meeting law presentation for Mr. Yu? It was a Pima County attorney.
Does the host have a copy of your presentation?
Yep.
Yes.
We're getting it set right now.
Okay, host can share it.
Yeah. Yeah, I sent it in the email.
You sent that, right, Diana?
It should be listed under county attorney.
There was a bunch of attachments sent at the end of yesterday.
Mr. Yu, would you mind getting started with, in this group, everybody on this committee has been through several committees and open meeting law training, so maybe if you want to start based on what you have, and we can catch up once we get the presentation loaded.
Sounds good.
Thank you.
So I understand that the committee members have experience on previous committees, so I will probably go through this a little faster than I would if open meeting law and conflict of interest was a brand new topic for you. But open meeting law is the sunshine law. That's what it's been called. It opens government business to public scrutiny and prevents secret decision making. As you know, meetings shall be open to the public. Meetings of public bodies must be public. Anyone can attend and listen to deliberations and proceedings, and all legal action must occur in a public meeting. Along with it is notice. All meetings have to be properly noticed. Notice must include an agenda sufficient to convey what will occur at the meeting, and staff from the county administration will assist with that effort. And generally with open meeting law, they're construed in favor of open and public meetings. That's how an investigating agency would look at it, and also how the courts would look at it. Who must comply? There's a good list of boards, commissions, and whatnot that must comply, but that also includes advisory committees. And that advisory committees are officially established on motion or order of the public body with the specific purpose of making a recommendation to the public body for some action. So a refresher as to what a meeting is, that is any gathering of a quorum. It can be in person or through technological devices at which legal action is either proposed, discussed, deliberated, or taken. Quorum means a majority of a board or commission, which in this case would be 3 of 5 committee members. And what constitutes a legal action? Well, that is a collective decision, commitment, or promise made by a public body. What has changed a little bit over recent years due to the nature of COVID is more discussion about electronic communications and how that can constitute a meeting. That can be basically how that happens is an exchange of electronic communications among a quorum of meetings, of members of a public body, and involves discussion, deliberation, or the taking of legal action about anything that can come before the public body for action. What that also includes is a one-way electronic communication by one member that is sent to a quorum. So I'm on slide 12 right now. It includes a one-way electronic communication by one member that is sent to a quorum of members of the public body, and that proposes legal action. For example, a member sending out a text message or an email saying, I think we should support option 3. That would create what is a meeting, and that would not be permissible. Moving on to the next slide. There is an exception with communications with the media. It's not a violation of open meeting law if a member personally expresses an opinion or discusses an issue with the public through the media or other form of public broadcast, as long as it is not principally directed at or directly given to another member, and there's not a concerted plan to engage in that collective deliberation to take legal action outside of a legal, publicly noticed meeting. Going on to the next slide. Essentially, open meeting law requirements require notice, an agenda, which provides that notice, allowing for public attendance, and also meeting minutes that come from the meeting. Next slide. The public body basically posts a statement on the website stating where all public notices of a meeting will be posted. That's going to be something that the county administration does with coordination with the committee. I'm not going to go into a lot of detail about that, but public notice is essential to the process. Next slide. Which includes notice at least 24 hours prior to the start of the meeting, which encompasses Saturdays. It's given to the general public. There are a few exceptions that can occur with recesses, with actual emergencies, such as natural disasters, and also ratifications that, and these things happen on rare circumstances. Going on to the next slide. The notice of meetings includes the details for the public to get to the meeting. Date, time, place, and agenda. With virtual meetings now, that includes information to log in to actually attend the meeting. Going on to the next slide. 2 years ago, the Attorney General's Office, which is the main investigating agency for open meeting law, provided for some parameters for virtual meetings, basically stating that meetings held can be held remotely through technological means, but basically that there is a way for someone to access it through providing the website location or a conference call number, providing technical support for questions for accessing the meeting. And that's where staff will assist with that as well. Going on to the next slide. Agendas need to list specific matters to be discussed, considered, or decided at the meeting. It's got to provide specific enough information and reasonably necessary to inform the public and the members. And when in doubt, the agenda should provide more detail. Going on to the next slide. And I know I mentioned that before, but the public body may discuss, consider, or make decisions only on matters listed on the agenda itself and other matters that are closely related. Next slide. So there's some agenda pitfalls that can happen where it's not readily comprehensible to the public. There's legalese, acronyms, or technical terms, or they can be a little too general for the public to really know what's going on, say new business, old business, announcements, reports, open discussion, training. That's why the agenda for today mentions what kind of training that we have in this meeting. Next slide. So one general category, current events, is something that doesn't need to be quite as specific. If there's a presentation from the county administration, then that is something that can be what's listed on the agenda. But generally, it's not a catch-all to present items that are not properly agendized. That should still be the goal, to provide that public, to provide that notice to the public. Next slide. Public attendance. The public has the right under Arizona open meeting law to attend, listen, tape record, or videotape meetings. They don't have a right to speak unless allowed or required by the statute. Under state law, call to the public is optional, but through these meetings, there is a process for the public to participate. They just can't disrupt proceedings. They have their time to speak. Next slide. The public body can't require the public to sign an attendance sheet, but of course, with minute taking, they can be required to mention what their name is. The public body can't hold meetings in remote locations or have it not be accessible through virtual means, given that these meetings are now virtual. Basically, meetings have to be held at reasonable times. Next slide. So with these public hearings, when the public is allowed to speak, there can be time, place, and manner restrictions. Speakers' time can be limited. There can't be any limitations based on First Amendment rights on what their viewpoint is, but their time can be limited. There can be repetition that is banned if a lot of speakers are speaking on a particular topic, and of course, they can't be disruptive. Next slide. Going back to if an issue is not on the agenda, members can't discuss it or enter into dialogue with a speaker who brings up a new issue when they are speaking to the committee. Members are allowed to instruct staff to study the matter that is raised, place the matter on a future agenda, so it is actually noticed to the public, and respond to any personal criticism. Next slide. That 2020 letter from the Arizona Attorney General's office talks about virtual meetings. And members of the public can be asked to identify themselves when they're speaking. The committee can ask the participants to mute microphones and phones when not speaking, as to not disrupt the meeting. Part of the preparation for the agendas, including copies of presentations and documents that will be discussed at the meeting, posting any information relevant to the meeting on the website, and that's where staff can assist. And also, it can be good to have the meeting recorded so that they have access to it. Next slide. There are some rare statutory exceptions for conducting business outside of the public through executive sessions. I've listed them so that you can see what they are. Most things have to be held in public in regular session. Next slide. When there are executive sessions, only members of the public body, people that are subject to any personnel discussion if that happens, any people whose presence are reasonably necessary, clerk taking minutes. If it involves legal advice, the attorney would could also be allowed in the meeting. The minutes are required for executive sessions, but they are confidential and not readily accessible to the public. Next slide. So generally for minutes that are not in executive session, they must be kept and made available to the public, and that's where staff will assist. They can be written, in other words, a statement of legal actions, or recorded, which can include audio or video. And it must be available for public inspection for advisory committees within 10 days. It must be reduced to a form readily accessible to the public, such as making the recording available to the public. Next slide. Minutes generally include the information needed by the public to understand what happened, date, time, and place, which members were present, what actions were proposed, discussed, or taken, any general descriptions of matter discussed, if there's not a recording available. Next slide. So this is just continuation of some of the details that are required for the minutes, which staff will assist with. Next slide. Now let's talk a little bit about open meeting pitfalls. We'll talk about serial meetings, splintering of the quorum, spoke and wheel meetings, email meetings, and social gatherings. Next slide. Next slide. With serial meetings, that are serial communications. That is when statements are communicated by one member to another, who then communicates that statement to another member. And ultimately, if that number is bigger or equal to the quorum, then there has been a meeting as constituted under state law. And if it wasn't on an agenda, that would be a violation of open meeting law. This tends to happen or could happen more frequently through electronic communications because of the nature of group texts and group emails. Next slide. Splintering and polling. So splintering the quorum or polling is not allowed. This happens when individual members have separate or serial discussions with the majority of the members until the information received from each member to the other members. So this is where avoiding the appearance of impropriety is a good thing to do. Next slide. This is called spoken wheel. This concerns communications by members through staff and others. Members can't use staff to circumvent open meeting law. For example, a member asking staff to distribute materials or information to all the other members. And staff or another person who knowingly helps evade this compliance can also be subject to sanctions under state law. Next slide. So the bottom line is it is a violation of the open meeting law to conduct discussions and or deliberations even between less than a quorum of members if the purpose of the discussion is to circumvent the purposes of the open meeting law. Next slide. So email. In terms of proposing, discussing, deliberating, or taking legal action, it applies the same through email or any electronic communication platforms, such as texting. Next slide. So one way to think about email is that it's evidence made available in litigation. Email among a quorum could lead to a potential violation because it constitutes a meeting. It is okay to receive email from staff if a member's response is limited to responding to the staff person. Watch out for replying all, because that can create open meeting law issues if there is discussion about the topic. And it can be helpful for staff to have a reminder about open meeting law, to remind them not to forward it to other members of the committee to make sure that open meeting law is complied with. Next slide. Events or social gatherings could also become a meeting. If quorum of members of a committee are at the same event or social gathering, be careful not to discuss anything that is remotely or even tangentially related to the business of the committee. Next slide. So what happens if there is a violation of open meeting law? Actions taken in violation of open meeting law are null and void. They would have to be ratified to make them valid within 30 days of when it was discovered or that when it should have been discovered. Ratification doesn't solve the issue of open meeting law violations, although it basically fixes the issue for actions that were taken that were null and void. Next slide. And this is just a little in the way of detail for how it works in terms of ratification. It's got to be, the public has to be notified about it. Intent to ratify, describe action to be ratified, and information about what preceded and related to the action. Next slide. There are potential individual penalties for open meeting law violation. Unless timely ratified, first of all, they can be null and void, the action that were taken. The court can order that a meeting be open to the public. A member of the public, the Attorney General, or the County Attorney's Office can actually bring a lawsuit for an open meeting law violation. And the court can order compliance or prevent a violation from occurring. Next slide. And as to individual penalties, the court can actually impose a civil penalty against a member who knowingly violates the open meeting law and anyone that aids, agrees to aid, or attempts to aid in the violation. While there's no monetary penalty for the first offense, the court can impose increasing penalties, $500 for the second offense and up to $2,500 for the third and any subsequent offense. Next slide. The court can award successful plaintiff that brings a lawsuit reasonable attorney's fees. The appropriate, the county potentially could pay fees, except that as set forth. For violations, the court, for more egregious violations, the court can actually remove the member from office and assess costs and attorney's fees to the plaintiff. Generally, the county is not able to defend members in open meeting law matters. Next slide. So the public body may not pay a fine assessed against a member or other individual and isn't allowed under the state law to hire counsel or expend monies for legal services to defend against open meeting law challenges without any specific legal authority to do so. There is the one way it's possible, but that's the rule for that. Next slide. The bottom line is focusing on transparency will keep you out of trouble. It also builds public trust in what you do. Next slide. And there have been resources that have been shared by the county administrator's office in regards to open meeting law resources. Each member of the committee must review the open meeting law materials at least one day before the day the person takes office. So I'm sure you've reviewed these. But just as a reminder, the clerk of the board website has materials relating to open meeting law. The Arizona Attorney General Agency Handbook addresses this. And the Ombudsman has materials relating to open meeting law as well. And staff may also be able to assist with any questions that you have. Does anyone have any questions specific to open meeting law?
Yeah, this is Larry Hecker. I have a question concerning communications among board members. Let's say I've come up with a proposed redistricting map. Is there a way to share that with the members of the board prior to a meeting, assuming that it's all at the same time going to be made available to the public?
That's something I would be cautious about. that is something you can talk to one other member about and also provide that to staff, and then that can be discussed during the meeting itself with everyone.
Something like that could be provided to staff and included on the agenda?
Yes, and then staff can make that available at the time of the meeting.
Very good.
Any other questions? Okay, in that case, we will move on to conflict of interest. That is a shorter presentation.
Mr. Yu, can you start again like you did last time and we'll catch you up?
Certainly, I can do that. So the background of conflict of interest is that it removes or limits the possibility of personal influence affecting an official's decision. It prevents self-dealing by public officials, and it applies to a variety of boards, commissions, and committees, which includes advisory committees. And that is how it's been described in court cases as the reason for it. Arizona law, specifically ARS sections 38-501 through 38-511, sets forth the minimum standards of conduct for employees, officers, and other members of public bodies in conducting government business. Individuals should examine their personal interests and involvement in the matters which come before them for decision or discussion and avoid any action on such matters. Now, what constitutes a conflict of interest? It is prescribed under state law, ARS section 38-503, and it essentially says any public officer or who has or whose relative has a substantial interest in any decision or a public agency has a conflict of interest, and that includes anyone that any public officer or whose relative has a substantial interest in any contract, sale, purchase, or service to such public agency. Relative is a bit of a term of art. I'm on slide 5. Because it is specifically defined under state law to include spouse, child, grandchild, parent, grandparent, brother or sister, whole or half, spouse of brother or sister, spouse's parent, brother, sister, or child. So this encompasses grandparents, grandchildren, as well as close family of your spouse. So moving on to the next slide. What constitutes a substantial interest? Now, a substantial interest includes any pecuniary interest. So that relates to money or financial interest. So something where a member could benefit monetarily. Any proprietary interest related to ownership, so specific to property. And any interest that is not defined under state law as remote. Next slide. So a substantial interest is something of value that can be gained or lost based on the decision of the government is considered a substantial interest. It does not include contingent or speculative interests, things that may come up. They may ultimately be issues down the road, but that doesn't create a conflict of interest. General sympathy, feeling, or bias, including ideological views towards or against something, does not count as a substantial interest, as it is not pecuniary or proprietary. Next slide. Now, what is a remote interest? I'm not going to go into the entire list of it, so I'm just going to show through this line. There are a lot of things that can fall under remote interest, and here are some of them. If we go to the next slide, there are some other ones that fit under remote interest. Next slide. So it's good to look at the specific statute or look at the Arizona Attorney General Handbook on that. for the specifics. I'm not going to go into that in great detail here. Going on to the next slide. The analysis to think about is, will the decision that is before the committee affect either positively or negatively a direct, non-speculative interest of mine or my relative? And is this interest pecuniary or proprietary? Could it affect a financial interest or an ownership interest? And is this interest other than one the statute says is a remote interest? If the answer to all three questions is yes, a substantial interest and therefore a conflict of interest exists. Going on to the next slide. So if there is a substantial interest, what should you do? You should stop, withdraw from all participation in the decision. That includes communicating about the matter with anyone involved in the decision-making process, which would include the other members. And disclose. File a written disclosure with the staff person, with the county administrator's office, or announce the nature of the conflict on the record, and then file a copy of the minutes with the staff person for the committee. Next slide. And just a reminder of other prohibited acts. A public officer can't represent another person before the Committee on Matters in which they have any direct involvement for 12 months. Not all of these are probably going to be relevant to the advisory committee, but this is just a quick reminder that these matters are prohibited under state law, including receiving compensation for any matter pending before the public body. Next slide. There can also be individual penalties for conflict of interest violations, which include potential criminal charges. It's a Class 6 felony to knowingly or intentionally violate any conflict of interest provision. It's a Class 1 misdemeanor if the violation is negligent or reckless, such as not knowing about a relative's involvement. That's not actually a defense under the law. And it's a Class 5 felony to knowingly falsify, conceal, or cover up a material fact to defraud in any manner relating to county business. Public office is forfeited under conviction, so that's something to be aware of. Next slide. There are also potential issues for the committee for conflict of interest violations. Just like with open meeting law, the decision can be declared null and void if a private citizen proceeds with a lawsuit, and the court could award costs and reasonable attorney's fees. And I don't think the next section is probably going to apply to this committee. Last slide. There are resources available in terms of conflict of interest if you want to look at, say, the remote interest more thoroughly. That includes the statutes which are listed there, 38501 through 38511, as well as the Arizona Attorney General Handbook, Chapter 8. And I can take any questions if you have them. If there are no other questions, that concludes the training for open meeting law and conflict of interest. Thank you.
Steve, you need to unmute. You know, it's the first time I've used WebEx, and all of the prompts are backward from all the other software. So pardon me for my ignorance. That concludes item number 5. Item 6 is the overview of redistricting requirements and resources, and who will be providing that information to us?
Mr. Lynn, I'm going to go over that, and it's a relatively short presentation. It goes over the main points that were included in the December 7th board memorandum that we shared with you. And as soon as I have the ability to share in a minute, I'll start on that.
And the floor is yours.
There we go. Thank you. All right, so Pima County redistricting requirements and resources. So why do we have to redistrict, or why does Pima County have to redistrict? And we have to do so because state statute requires us to do so. Every 10 years after the DCNL census and the data is transferred, we are obligated, or the Board of Supervisors is obligated, to adopt revised supervisorial districts that balance the population to within 10%, meaning the highest and lowest populated district must not be more than 10% difference. This is the current population variance, and also the variance that we experienced back in 2011. So 2011 was the last time that we redistricted, and you can see the districts on the left there, and the middle column shows a 2% difference in the highest and lowest populated district after the prior redistricting effort. Now that we've received the data for the 2020 population estimates, we have about a 16% difference between the highest and lowest populated district, with the highest populated district being District 4 and the lowest populated District 5. Redistricting, or county redistricting, we also have to maintain compliance with the U.S. Constitution and the Federal Voting Rights Act. This has become more complicated than it was 10 years ago, and so we will be relying more extensively this time around on our county attorneys and on expert attorneys that they've retained for this part of the compliance, and I'm sure we will be having discussions about this in the future. Other redistricting considerations. So the Pima Community College Governing Board runs on the same district lines as the Board of Supervisors. This year in 2020, 2 seats are up for election on the Pima Community College Governing Board, District 2 and District 5. There are no seats on the Board of Supervisors that are up for election in 2022. All of ours are in 2024. Voter precincts, when you think about the mechanics or the mechanism of reprecincting, we rely on the use of voter precincts as the building blocks to redistrict. And recently, the Arizona Independent Redistricting Commission adopted revised legislative and congressional districts, and some of those split voter precinct lines. So we're currently going through a process that the Elections Department is leading to adjust those precinct lines. And so in the future, the maps that you will be looking at will be based on those revised precinct lines. The Recorder's Office has also requested that as you go through this process and consider where to move and revise the district lines, that you don't further split precincts, so that they will be ready in June to have their voter registration system basically locked down in June and ready for early voting for the primaries in July. Unlike congressional and legislative redistricting, which some of you have been involved in or just heard more about, so counties can simply move current district boundaries, or move voter precincts in and out of current district boundaries, and do not need to start from a blank slate. And then you may also have heard of traditional or more common redistricting principles, including maintaining geographic contiguity and compactness, as well as respect for natural and man-made boundaries and communities of interest. So mapping and data analysis. So I am going to ask Eric Glenn if he can give us a little bit of an introduction to the systems and the platforms that he's going to be able to share with you in the future. Eric?
Thanks, Nicole. I'm not sure if I can present. If not, there we go. Can you see that?
No, we can't.
How about now?
Nope.
Not yet.
Okay, sorry, I don't know. I guess I don't know how to do that. But just a quick overview. We have a web platform called Districtor that we are in the process of standing up. We had to wait because the voter precinct lines changed very recently. So we had to recalculate all the demographic data for the new voter precincts. But that platform should be available for the next meeting. It will also be the platform that the public will use to submit plans. Again, it's called Districtor, and it's probably what I will use during the meetings as well, so that when committee members decide how they'd like to start moving voter precincts around to create new supervisor districts, I will use that platform, and share my screen, and we can all see it. So that should be up and running next meeting. I guess the one question that we may want to figure out between now and then, whether that's staff or the committee, is should committee members be submitting plans on their own? It sounds like probably not. But if that is a possibility, committee members can also create plans on their own.
All right, Eric, did you have anything else to add?
No, let's see. Can you see that now?
Yes, we can.
Okay, so this is the website. Again, it's called Districtor. I'll just do a quick little tour of it. Here is an example. This is Yuma County. They already have a plan site set up. And you can see over here we have several tabs that we can, when we start drawing and adding voter precincts to a specific district, we can see what the population and some of the other variables will be for each of the districts. And we can do this live on the fly. So it's a very nice platform, both for the public and I think for the committee. The other good thing is that we can share maps that the public submits on a kind of a landing page, so to speak, and we can look at those draft plans on the fly. And so anybody that submits a plan, we can evaluate it either during the meeting or otherwise. And again, we will have that somewhere on the county redistricting page. We'll have a link to that Districtor website. So I will stop there unless anybody has any questions. Again, that should be ready for the next meeting.
Eric, I got a question for you real quick. The data that goes into that mapping software, who, for lack of a better term, synthesizes that data from the census data and puts it in there, or is it automatically transferred from census data in there? What's the process for creating that map in the first place with the sub-tabs and the data?
That's a great question, Mr. Antonori. I am putting that data together. So I'm using, for the most part, the new 2020 census data that was released. We're basically interpolating it from census geography to our voter precincts. And so that's how I'm coming up with that. I will submit it to the Districtor, basically staff. I'm actually going to do that today or tomorrow, and then it will be ready for the next meeting. The only thing that I have had to calculate myself is citizen voting age population, and I'm using the same methodology that the state IRC used. So all that data I am creating for our current voter precincts.
So is that data available to us in the public as well, or is that not?
In a form? In other words, when you start creating a map, that data will be available, yes.
No, I'm talking about the raw data that you have access to that you use to build that map. Is there a site? So nothing against you, Eric. I'm just Mr. Check and Balance. I just want to make sure there's another mechanism so that we could just want to spot check and validate maybe whether we think there might be a mistake or the data might not be 100% accurate, or we have other data that may say otherwise. Is there a way we could validate that or check on that or not?
I'd be happy to put a spreadsheet or any other format that the committee would like onto our county redistricting page. And again, that would be by voter precinct. All the data that's going to be used in the Districtor platform, I can provide that in a spreadsheet format. And then obviously the actual census data that I took that from is publicly available. You know, we can provide links to it. So there are a variety of ways I guess we could handle that. So
yeah, I don't want to create work for you. I just want to know where I can go if I want to go look at it.
Right.
So that, yeah, the census data link would be helpful.
Okay.
That you're using. So that would be sufficient. I don't need an Excel spreadsheet.
Okay.
Unless the other guys and gals on the committee want one. I don't know. I don't need it.
Mr. Antonori, I take your question to mean, is there a trusted source of information of these things that we can all use as the same standard?
Right. Not against Eric. I'm not trying to impugn his integrity. But, you know, I live in a world where data in equals data out, right? So if you can influence the data going in, you can influence the data going out. And I'm just saying that there's got to be some kind of validated way to verify. And again, Eric, I'm not saying that you would do this, but I'm saying if somebody were to alter that data other than what is portrayed in the census data or something different, if there's a way, if there's a mistake, you know, what if he types in the wrong number? You know, he's transferring something or downloads it accidentally into the wrong precinct or something. I'm just saying, is there a way to verify that? That's all I was looking for.
And I think the answer is we can always go back to the source of the data and check to make sure that the numbers there square with the numbers that we're using in whatever form we have.
Right.
Fair enough?
Fair enough.
Any other questions for Eric? Eric, any more information that you'd like to share with us today?
No, I think Nicole asked me to keep it to 2 minutes, and I obviously went way over that, so I will stop it there unless anybody has any other questions.
When would we have access to Districtor?
Again, I'm hoping, I asked them to have it ready in 2 weeks before the next meeting, whatever we decide that date is going to be. So that shouldn't be a problem. If it is, you know, we'll let you all know as soon as possible, but it should be available in 2 weeks.
Thank you.
Other questions or comments?
Mr. Chair.
Nicole, anything more?
Yeah, I was just going to add to part of this, or part of the delay was not on Eric's end, but with the Arizona Independent Redistricting Committee impacting those precinct lines, you know, breaking the data down into the new precincts has been, we've had to wait on that. And even now we don't have an absolute approval. So he's working on draft precincts or using it at that level. Mr. Chair, I just had 2 more slides, if Sean will give me permission to share again. Thank you. And this was an example that was provided in the December 7th board memo, but we as staff are going to be looking to the committee for direction, and it could be specific direction in moving specific precincts, or it could be something like, you know, what is the least amount of change that would get us to compliance with state law by balancing the population to within 10%. So this is just one example of what this could look like. We are zoomed into Eastern Pima County. You can see the 5 districts in different
Nicole, your
colors.
slide's not up. Eric is still up on the shared screen.
You can't see it? I can see it on my screen, of course.
Not yet.
All right. Oh, there you go. Thank you. And then it goes back to the other ones. All right. So zoomed into Eastern Pima County. Western Pima County is within District 3 and is not shown on this map just for the purposes of demonstrating this particular example. So if the committee was to say, what would it look like if we wanted to make the least amount of changes and balance the population of the districts to within 10%? If you look towards the center of the map here, there is a precinct 69 that is currently in District 4. And if that precinct was moved from District 4 into District 5, that would get us just under a 10% difference between the highest and lowest populated districts. And again, pending any review by our county attorneys with regard to federal compliance, that would achieve that statutory requirement. So this is just one example of how we could come back to the committee with direction. If you said, could you give us an example of where you reunite Sahuarita, for example, within one district? You know, so we would go back and forth and provide you maps in response to your direction. And then just to summarize the public process, so the committee's meeting now through April, hopefully having at least 5 meetings that are public meetings to develop a recommended map. In May, the Board of Supervisors would hold a public hearing before adopting the final map. And that's our redistricting webpage link there, and Eric brought that up for you. We have a group of stakeholders that are, in addition to the public, that we are notifying about these meetings and opportunities for public input, or comment. So the Pima Community College Governing Board, major political parties, language minorities, including the tribes, cities, towns, unincorporated community councils, the League of Women Voters, and our Pima County Elections Integrity Commission. And for the public, we're doing press releases, social media posts, and providing information in county newsletters as to when your meetings will be and opportunities for comment. And that's all I have, Mr. Lynn.
Thank you. Questions or comments, Nicole? I wanted to comment as Nicole was making her presentation. If you recall, she indicated that the redistricting group from 10 years ago achieved a variation of 2% among the districts. And I think Dr. Romero and his colleagues deserve an incredible amount of credit for being able to put together districts that have that little variation. That is essential on the one person, one vote issue, and with the other restrictions that are imposed by voting rights and others. That's quite an achievement. I would hope that this group would aspire to be as good as the group last time in terms of the variation in population. Well done. Are there any other comments or questions on item 7?
Mr. Lynn?
Yes.
My question is, if we need more data or different type of data, how do we go about acquiring that information?
I think we would make that request of staff, and to the extent that the data was available at either for whatever source might have it, I'm sure they would try to provide us with anything we might wish to have. Okay. Nicole, you want to weigh in on that?
Yep, that's correct.
Yeah, that was the process the last time. I just wanted to put it out there and just to clarify. I didn't want to make any assumptions.
Sure. And clearly, we're going to get lots of input from lots of places on lots of issues. And our job is more of a balancing act than it is much of anything else, to take all of that information, synthesize it under the restrictions that we have under the law, and still come up with 5 districts that will be workable for the county. And certainly, we're committed to doing that. All right, any other comments or questions on item 7? If not, item 8 is a discussion about our meeting schedule. You were given a proposed schedule. Our requirement is to have at least 5 meetings, and I don't believe for a minute that we're going to escape with only 5, but for the sake of planning, was there any objection to the dates and times of the meetings that were proposed in the material that you received? Do those dates and times work a hardship on anyone on the committee?
Mr. Lynn?
Yes, please.
The only date that has a slight bit of conflict for me is the 14th for obvious reasons, Valentine's Day.
You know, I kind of had that same problem myself, Dr. Romero. I mean, I could be in big trouble as well as you, and if we don't adjourn early enough. I think one of the reasons we want to go late in the afternoon is because at call to the public, we want to make sure we hit people who have work and are able to access us through a public meeting. But if there's an appetite to change that 14th to perhaps the day before or the day after, I think that would be fine if staff can accommodate that.
In regards to staying on Wednesdays, my recommendation would be just to move it to 2 days later and have it be the 16th of February, which is a Wednesday.
So, Mr. Chair, we struggled with that week because in order for us to televise the meetings on Channel 96, we need to have access to the boardroom, and we were not able to get, or other parties have reserved the room at this time. But what we'll do is find out who has and see if there's a way to provide them with optional accommodations in order to accommodate this committee.
Yeah, Nicole, why don't you research which days that room is available to us? And if there are multiple dates, do a little doodle poll with us to see if we can arrive at a date. Unfortunately, the 16th doesn't work for me, but if we can get something in the near vicinity to the 14th that is available, we'll try to make that happen based on everyone's schedule.
Will do.
Great. Any other comments on the schedule as it's presented? All right. If not, why don't we,
Mr.
with
Chair?
the exception of the
Sorry, Mr. Chair, is there any objection to us publishing the meeting schedule as a tentative meeting schedule once we get that next meeting date set?
No, in fact, that schedule should be published as quickly as possible so that we can begin to solicit public comment. As long as there's a caveat on the 14th that it may change, I have no problem. Is there any objection to publishing that list now?
No. No.
I hear none. So please do so.
Mr. Chair?
Yes, please.
Just for the convenience of the staff as well, should there not be an opportunity to move it to a closer date or time or during that week, I will make the 14th work. But I just, if we can make that accommodation, that would be great. Otherwise, I'm 100% in.
We will attempt to do so, Dr. Romero, but we appreciate your flexibility very much. Anything else on meeting schedule? Nicole, would you like us to formally adopt that tentative meeting schedule?
No, it's fine. We don't need you to adopt it.
Okay. Very good. Hearing nothing else on item 8. Now, this meeting was noticed, and I would ask the clerk if she received any notifications of any members of the public who wish to address the committee at this time.
And we haven't. I'm going to turn it over to Diana Duraza, though, who received at least one comment that she'll read into the record for you.
All right. And Diana, if you would please, so no one else has asked to speak, but we will read one comment into the record. Is that correct? Diana, is that correct?
Oh, she's on mute.
Sorry, yes, it's on mute. I apologize. I'm trying to bring it up.
There you are. So no one is going to speak, but you're going to read one comment into the record.
Correct.
Please do so.
Okay, and the comment was from Gail Skinner. And the comment submitted was, in my opinion, there should be no such thing as a safe district for any political party or person. And as of that time, for today, this was the only comment we received so far.
Okay, thank you very much, and we'll make that a part of the record. That actually concludes our agenda for today. In just some closing comments, I want to thank you, members of the committee, for the confidence that you have shown in me and Dr. Romero as your leaders. We will try to lead with a very soft hand and give everyone an opportunity to have ample time to participate in this process. It is too important not to have everyone's input considered. And my goal, certainly as chair, and I hope Dr. Romero agrees with me, I don't like 3-2 votes. I don't like them at all. I don't think they help anybody. And my goal would be to work through things so that we have much more consensus than a majority vote on things. That's my goal anyway. We may not achieve it, but I think if we work hard and talk to one another through our formal meeting process, I think we can achieve a better outcome and a much more consensus view of how these districts should look. So that would certainly be my goal. Dr. Romero, do you want to add anything to that comment?
No, we are 100% in line, so I appreciate that, and I'm with you. Thank you.
Great, thank you so much. Having no other business on the agenda today, we are adjourned. I'll look forward to seeing you at the next meeting, pending my WebEx working better than it did today.
Thank you, everyone.
Thank you all very much.
Thank you, everyone. Thank you.
So, because you were unmuted here and here.
Gotcha, I'm sorry. That was my mistake.
Yeah,
That was my
don't
mistake.
ever unmute the computer.
Yeah.
But you
guys mute her computer for her if she does that?
Yeah, he's,
Oh, okay.
he's not used to doing it.
Okay.
You know,
Well, we'll know that